Thank you. Please be seated. Good morning, all. Do we have a sign-in sheet before we get started? Thank you very much. This is a time set for oral argument in State versus Michael Abbott, our case number CR14046. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to reserve a portion of that time, you'll need to keep track of your own time using the clock at the podium. Out of respect for counsel, I would ask those in attendance to make sure your cell phone is turned off so our presentations aren't interrupted. We have reviewed the briefs. We've conferenced the case this morning. We'd encourage you to keep that in mind as you make your oral presentment to us this morning. Our proceedings are being recorded and will be posted to YouTube in due course. Accordingly, we'd ask that you, when you take the podium, please tell us your name and the party that you represent. With that, Mr. Nolan, you may proceed.
Thank you. May it please the court. Your Honor, my name is Todd Coolidge. I work for the Nolan Law Firm.
Very well.
And may it please the court and also counsel for the state, Mr. Christ, thank you for today, the opportunity to represent Mr. Abbott here. What I believe is the most important argument out of the five that were raised in our brief is the first Justices, the denial of the motion to continue on the day of trial. Rule 8.5 said that motion should be granted if there are extenuating circumstances and it's indispensable to the interest of justice. The court ruled that the case had been pending long enough, and the new charges that had come up just a few days prior were not serious charges and wouldn't really affect this Class 3 felony that was a dangerous offense. This was an abuse of discretion, and that's the standard for the denial of a motion to continue. The court did not feel that it was important enough to keep pushing this case forward when just 2 months prior it allowed privately retained counsel to withdraw even though the case had been set for trial. And I'm not sure how that happened, because normally when a private counsel either comes onto a case or gets off a case, new counsel has to avow they're ready for trial. And I don't know how they would even have somebody from the public defender's office there to say, yes, we're ready for trial. If it happened on July 2nd, that means it's probably, in just having worked for the public defender's office 17 years ago, that case probably was not assigned till the end of July to the counsel who then tried the case. The court was also very wrong about the seriousness of these charges. They felt that, well, it's a Class 6 felony, possession of marijuana, possession of drug paraphernalia, and that doesn't really carry a lot of weight to it, and we've got a Class 3 dangerous offense here. The state, in their brief, has indicated that under Prop 200, or the 13901 section that it now has become codified to, that he would be given no jail time or no prison time, and that's incorrect, because once he is convicted on the Class 3 dangerous offense, it becomes now a serious prior, which would make him ineligible for the Prop 200. He could go to prison on that.
Counsel, there's no argument that those cases would be tried together, is there?
No, absolutely no. They could have been resolved together, though.
Well, but having trial move forward, did that preclude that other case from being resolved?
It did not preclude the resolution of that matter, but it could have if he had gone to trial, or he pled guilty. It meant that he was not ineligible for prison or confinement under Prop 200.
Well, but let me ask you just practically, the argument here wasn't that defendant wasn't ready to go to trial. It was that these new charges had some effect, potential effect, perhaps for this case, but more significantly for the new charges if trial went forward, which is not, and the motion to continue itself wasn't timely filed, as the face of the motion expressed, and inconsistent with the administrative order about timeliness. And isn't this court directed to afford a trial court pretty broad discretion in managing its trial calendar, particularly where there's no claim that the defendant wasn't ready for trial on these charges, and there's a motion to continue filed the day before?
Yes, this court has the ability to allow the trial court discretion in making those decisions, but I think the decisions that were made here actually has caused prejudice to the client, cost the state quite a bit of money for a 2-week, 10-person jury trial.
Let me ask you about the prejudice, and we'll hear from the state if on their concerns about cost. But how did that prejudice this case?
Here's why I believe that prejudice is the case. Again, there was a previous offer to a Class 3 non-dangerous, a Class 6 non-dangerous stip to prison with a range of 3.5 to 8.75. That's the presumptive to extraordinary maximum on a Class 3. The judge at sentencing ultimately came down with the presumptive sentence on everything. Had that been the case, and he had taken the original offer, he would have wound up with 3.5 years. The marijuana charge, while it did not become an aggravating factor, became something that the court could consider at the time of sentencing as to determine whether or not to go below the presumptive of 7.5 on the Class 3 dangerous felony. In his mind, thinking, well, we have a person who was on probation for a misdemeanor offense when he committed this Class 3 felony, which involved substantial amount of alcohol consumption. And now we have a subsequent charge that also involves an illegal substance, and that may have been playing in the judge's mind, and rather than giving the mitigated sentence of 5, now there's this new conviction with new evidence that could make the judge think, well, I'm going to give him just the presumptive because the one aggravating factor that the jury found, and now this new charge outweighs any mitigation, which there was because of the defendant's age and lack of criminal history in terms of felony contact with the system. So that's how, and if the court had...
Doesn't that turn on the thought that if the trial in this case was continued based on the appearance of a new charge, unrelated, that the state then would have extended an offer that either was as favorable as a prior offer that was rejected or even more favorable, and your client would have then decided to accept that offer? I mean, isn't that kind of what you're arguing?
Yes.
Okay.
And the reason I'm arguing that is this. The likelihood of the offer that would have come after that is take the original offer we had made to you, 3.5 to 8.75, followed by a probation tail on the new charges. And his attorney would have been able to sit down with him and say, look, it's not a Prop 200 case. You're not just going to get probation automatically on this new case. It could actually cause these two charges could actually run consecutive to each other, as the law presumptively says that they should. The Class 3 dangerous followed by the Class 6 possession of marijuana. And
so it's not just that the first offer looks better now than it did then before trial. It's that the consequences that he's facing on the first day of trial are worse because of the filing of the marijuana charge than they would have been otherwise. So the risk of going to trial now is greater, and it's not greater simply because you've got this other charge. It's that this other charge has raised the stakes for a conviction on the current charges.
absolutely.
Okay, I didn't understand that in your brief. Now I understand that. Okay.
Okay. And in addition, in the response brief, the state indicated, he should have known about these charges. They weren't that new. These cases come through. This was done by grand jury indictment, so it's a secret hearing. Nobody knows about it. That happened on the 16th of September, 2 weeks prior to trial. It probably gets mailed out as a summons, finally gets to Mr. Abbott. He relays it to his attorney, and they go in and ask for a continuance.
Well, but let me ask you, with respect to the charging documents, I have no reason to doubt the chronology, but with respect to the law enforcement interaction, your client knew of that.
I'm assuming he obviously did know about it, but again, that was probably a year prior, based on the amount of time it takes DPS to turn around testing in this case. And remember, he went from a public defender to private retained counsel, then that counsel withdrew, and then it went back to the public
No,
defender's
and
office.
what I'm talking about, though, is the new charge, the
Right.
marijuana charge. So, okay.
I'm saying that the trial counsel may not have ever had any inkling and never been told about that there had been some kind of contact with the police at that point in time. What I was going to, the state indicated that he should have known about these sooner. Again, as I indicated, these all came up just within 2 weeks of trial. I think September 16th was the grand jury indictment date. September 18th was a settlement conference at which nobody knew about it. The court didn't know about it. The prosecutor's office didn't know about it. The public defender's office didn't know about it. And had that come up then, in this situation, almost 100% of the time, new charges will continue a trial date. 100% of the time, because there's a chance we're going to avoid, as was here, a 2-week, 10-person jury trial and the cost to the state of that, and could have resolved the case. And I believe that that was the abuse of discretion. Here, again, the prejudice to Mr. Abbott was a presumptive sentence of 3.5, because we know now, in hindsight, he got the presumptive sentence of 7.5, a prejudice of 4 years of his life. And again, the judge may have considered those charges in determining what he was going to give him at the time. And it's also, one thing to note is they denied the motion, sent them to a trial division, didn't pick a jury till the next day, and then took a week off, because the state's witnesses were unavailable and something to do with court scheduling. So it wasn't such that the court couldn't have said, knowing that the state had already said, yes, we're willing to make a new offer, we're willing to sit down and go through this, bump it for 1 week. You already know you're going to come back and do that.
Let me ask, though, if did that preclude the parties from discussing a global resolution, given that you had a week?
Absolutely not. And I smile because I know who the trial counsel was, and I know what her policy is, that once a jury's picked, she's not.
And I understand that at some point in time, parties sort of move from good faith attempts to resolution to final trial preparation, but it's not at all clear to me that whether that week had been granted or not would have really made a difference. I mean, you weren't asking for a week continuance, were you?
And that was not our case, but at the time, I believe they were asking for a full 30 days so they could actually do plea negotiations. And with regard to the motion to continue, that's all I have. The second argument is the retroactivity of the McNeely decision, U.S. Supreme Court case of Missouri versus McNeely. And I know that our brief discussed the fact that the state is not afforded the same rights as the police in terms of a good faith basis. And in this situation, what I believe the state's misconduct was here is if at the settlement conference, the trial attorney said to the court, and it was in the record of the proceedings, that the blood was seized pursuant to a warrant, and the state knew that it wasn't pursuant to a warrant, and knew that at that point in time, McNeely was about 6 months old, and so knew what McNeely's decision was, that the state had that at that point in time, they should have told the defense counsel, you're incorrect on this. McNeely's out there. We should possibly litigate this issue. And it was not done. And there was a mistake before the court that the prosecutor just let go. And it should have been litigated more thoroughly than an offer of proof and give me some briefings on day 3 of trial, when it finally hit the trial counsel that, wait, this wasn't a warrant draw. And the reason why I believed he probably thought that is because there actually were 2 more draws, 1 hour later than the hospital draw, and 2 hours after the hospital draw that were drawn pursuant to warrant. And so now that McNeely has come out, the state had 2 other blood specimens that they could have offered at trial. The most, giving the benefit of the doubt to the state, the most that 0.255 would have dropped would be to 0.225 on the next draw, and 0.195 on the next draw. And even if you go another hour out, 0.165. And so we're talking about an extreme level of intoxication still 4-5 hours later, when they had 2 more warrant draws that satisfied every requirement that the courts have imposed and that McNeely is imposing, and could have addressed that. And obviously, knowing that that trial counsel was under this illusion that it had been a warrant draw altogether, should have addressed that issue.
How can we know that that particular prosecutor was aware that the first 2 vials were drawn without a warrant, if at all? I mean, the defense lawyer was unaware. How can we know the prosecutor was aware?
Because of her arguments at trial that it was a good faith reliance by the state that McNeely at this point in time shouldn't affect it.
But at trial, you're speaking, what I understand you'd be saying this morning is that misconduct occurred at a pretrial conference.
A settlement conference.
Settlement conference.
2 weeks prior to the trial date starting. So, and just based on the argument she made during trial, I know that prosecutor, was aware of that.
So she was aware of it at trial, but you're not sure that she was really aware of it at the pretrial conference. That's kind of speculation on your part, isn't it?
I would agree. I can't say for sure that she was aware of it at the settlement conference. I would like to reserve 3 minutes of my time, and I'm at 4:15 at this point. So what I'd like to do is jump to the improper endangerment instruction. And I believe that with regard to that instruction, that instruction should have also included the language regarding just physical injury, rather than focusing just specifically on imminent death, which would have left open the argument for the misdemeanor, or if the jury were able to see what the statute said and thought, well, really, this person was just they were in danger of something. If it was just physical injury that they thought he was the one officer that Mr. Abbott was convicted of, that should have included the language of just physical injury, so they could have decided that it wasn't the Class 6 felony.
Was a lesser included instruction requested?
I did not see that. I would reserve the rest of my time.
Very well.
Thank you.
Mr. Coolidge. Mr. Christ.
Good morning. Good morning. My name is Terry Christ, representing the state of Arizona. May it please the court. I'd like to begin with the jury instruction issue, which counsel just alluded to. And I'd like to start by saying that we are under fundamental error review here, not abuse of discretion, as they claim in their opening and reply briefs. The correctness of the jury instructions was never before the court, nor was a request for a lesser included offense. The only thing that was before the trial court was whether the Raji would have been more understandable to the jurors than the instruction actually given. The trial court had proposed departing from the Raji because the Raji did not have language about grossly deviating from the standard of care, and the court was concerned that this would actually give a lower burden for the state. So the defense counsel's response to that was, I do not object, this is a correct statement of the law, but I would prefer the Raji. So they did not preserve any issue of the correctness of the instruction or anything about a lesser included offense, and thus we're under fundamental error review. And under fundamental error review, the instruction is correct. A reasonable jury could read this to find that there is a conscious disregard of a substantial and unjustifiable risk of imminent death, and that the imminent death risk in fact occurred. Even though the jury instruction for recklessness itself speaks only about physical injury, the instruction for endangerment specifically refers to imminent death, and the jury would, reading these together, would realize that the risk needs to be imminent death. There is certainly no requirement for the court to sua sponte instruct on lesser included offenses like endangerment with the risk of merely physical injury. So there is no issue with this jury instruction even if there were, it wouldn't be fundamental error because it didn't go to the heart of any defense raised by defense counsel. Their only argument at closing argument was that the defendant did not grossly deviate from the standard of care. And they had no argument about physical injury versus imminent death and what risk was appreciated. Even if they had such an argument, the evidence was overwhelming here that the defendant, in the dead of night, is driving 70 in a 55, is drunk, doesn't brake before he smashes into the tow truck, nearly runs over a police officer. There were the lights from the V-pattern flares. There were the lights from the emergency vehicles. And even assuming that the jury appreciated or thought that the defendant appreciated any risk, it would have been for imminent death. So there's simply nothing wrong with the instruction, no error occurred. Moving to the second issue, the McNeely issue, again, fundamental error did not result because there simply wasn't prosecutorial misconduct. The prosecutor knows, of course, about McNeely, but also knows about Davis versus United States, which is very clear that if the police act in objective good faith reliance on existing law, then the search will not be excluded under the exclusionary rule, even if the rule changes. Essentially, what defense counsel is asking for here is to gut Davis, because under this rule, if the prosecutor knows about a new case before trial, they would have to follow that new rule under some heightened ethical duty that there's no authority for. But in fact, Davis applies any time after the search. So as long as the new rule didn't come out before the search and the police act in good faith, the prosecutor is entitled to admit the evidence. There also can't be misconduct because the trial court specifically ordered that the evidence would not be suppressed in the third day of trial, and the prosecutor is entitled to rely on that. It's essentially a safe harbor. They argue here and that the prosecutor should have mentioned somewhere during the settlement negotiation that there was a warrant, and again, it's speculative, especially on fundamental error review, to assume that the prosecutor even knew when the first time this evidence comes out at all is when the police officer testifies on the third day of trial. But even so, it wouldn't have made a difference because even if there wasn't a warrant, as there wasn't, that was an admissible search under Schmerber versus California, which was the law applicable at the time. So it wouldn't have made a difference because the evidence was admissible in any event. So there was no prosecutorial misconduct. As to the first issue, the continuance, the trial court did not abuse its discretion by denying the motion for continuance. I think it's important to keep in mind that a defendant is not entitled to a plea bargain, constitutionally or otherwise. And the trial court here has to weigh a variety of factors to decide whether the interests in delay outweigh the interest in going to trial. And here, that simply wasn't the case. The trial court had the discretion to make the call, and it was clear that the interests in going to trial outweighed the admittedly weak interest in plea negotiations. This trial was over a year old. The defendant had already received 6 continuances. This was made the day before trial. They were asking for 45 days when at most they needed a week. It was 45 days, not 30.
Let me ask you about that. At most they needed a week. What causes you to say that?
Well, the prosecutor stated at the hearing that she hadn't seen the file and might make an offer, but she made no commitment to making an offer and made no commitment on the decision itself. But realistically, it doesn't take 45 days to get a file and decide whether you want to make a plea.
And I understand that, but at times policies mean the plea offering window is closed when you're that close to trial. Is there anything in the record that would advise the court on whether that obtained?
There is nothing in the record about policies or the length of time or any of that.
Okay, but your position is a week would be more than enough time for the state to effectuate an offer if it chose to do so?
Yes, Your Honor. And in fact, they had a week because there was a week from the time of this hearing to the first day of testimony. And if the prosecutor wanted to, she was free to make an offer during that week.
But had jeopardy attached by then? Hadn't the jury been picked?
The jury had been picked.
And perhaps it hasn't been sworn where jeopardy would attach, but doesn't that kind of change the dynamic somewhat?
It does change the dynamic somewhat, but it wouldn't completely change the calculus. The prosecutor is entitled to make a plea offer in the middle of trial. There are cases to that effect.
That's not all that common, though, is it? Wouldn't you agree with that?
No, it's not common, but it's certainly possible. And the reasons for going to trial are more than just saving the state a lot of work and cost. There's also uncertainty. You never know what the jury is going to do with your evidence, even when you put on your best case. So If the prosecutor felt like this was a case where a plea was appropriate, then she could have made one, but chose not to. And I think part of what informs that is that the defendant had just rejected a plea offer 2 weeks earlier. It didn't include these charges, but it included the far more serious charges of the endangerment and the aggravated assault. And there was a range from 3.5 to 8 3/4 years there. And there's just no reason to think that the prosecutor would have made an offer that the defendant actually would have accepted in light of that. Moreover, there's simply no prejudice here.
If I can interrupt you on that, no reason to think argument. What I understand that the defense is saying is that there was reason to think that the analysis would be different now for the defendant, now meaning on the first day of trial, than it had been 2 weeks earlier at the settlement conference. And the difference is the knowledge of the marijuana charge, knowledge that the marijuana charge raised the stakes for a possible sentence on the endangerment charge. In other words, he faced a greater sentence on the endangerment charge because of the mere existence of the marijuana charge. Is that true?
Is it true that he would have faced a greater sentence?
Right. Did the marijuana charge affect the range? Better put, did the marijuana charge affect the possible range of the endangerment charge?
It clearly didn't in the sentence actually imposed. Perhaps it logically could have, but it clearly didn't affect what actually happened in this case. For one, it was a concurrent sentence for a year, so the charge itself didn't actually extend the amount of jail time he served. For another, he received the presumptive terms on everything.
But was the range different, though, because of the existence of the marijuana charge? I mean, I understand he received a presumptive sentence ultimately, but was the presumptive sentence a different sentence than the presumptive sentence would have been absent the marijuana charge? That's what I understand the argument is now.
I don't believe so, but the truth is I'm not 100% sure standing here.
Okay.
I don't think it made a difference, but part of that, too, was there's actually a third case, a probation violation. So any issues with multiple counts would probably have already been taken into account with that. And again, the court found a presumptive sentence because it didn't find any mitigating factors. It said nothing about the existence of this marijuana charge when deciding whether to give him a mitigated or presumptive. It just didn't find mitigating factors.
Okay.
But also, I think what's more important to keep in mind is that isn't prejudice. Prejudice for a denial of a continuance is something that would affect the fairness of the trial itself. So the defense inability to get witnesses in time or prepare arguments or something of that sort. And the defense counsel at the hearing said that but for this issue with the plea, he was ready to go to trial. So he indicated no lack of preparation. And I know that they say that the new defense counsel had just been appointed 2 months earlier, but he expressed no hesitancy in his preparation for trial. So that certainly wasn't an issue. The court wouldn't take that into account. And there just simply isn't prejudice because of it. There also isn't really an appropriate remedy in reversal in this case. Reversal wouldn't achieve any goal because we can't really put the parties back in the position they were at before trial because there was no offer on the table. So there's no specific performance of a plea like you would get with a ineffective assistance case. And again, this is not an ineffective assistance case. That would be in a Rule 31. You couldn't make that argument on appeal anyway.
Does your argument that there was no prejudice proceed in part from the principle that a defendant is not entitled to a plea offer? And as you point out, the only asserted prejudice is that I didn't get a chance to weigh a plea offer under the new circumstances. But you're saying there's no prejudice because he didn't have a right to that in the beginning?
Correct. And it's partially because he didn't have a right to it to begin with. It's also partially because the sort of prejudice that courts actually reverse on with continuances is the fairness of the trial and the preparation of counsel. So those two things together certainly lead to the conclusion that there was no prejudice. And ultimately, it's the trial court's call. The trial court's weighing factors here. The trial court has broad discretion to make this decision. And in fact, the trial court decided that the interest in going to trial in this old case with a lot of continuances outweighed any speculative possibility that the prosecutor might have made an offer that the defendant might have accepted that might have made a difference in this case. There's just too many maybes to say that the trial court abused its discretion.
Counsel, how the third charge, the new one that we're talking about here, the possession of marijuana charge, how long prior to the indictment coming down had that occurred? When was the incident that led to that charge? Do you know that?
I do not know. I'm not even sure if it's in the record.
Okay.
What I know is when the indictment came down and then when they filed their motion. But I do not know exactly when the actual crime and arrest would have happened.
Okay.
I submit that it wouldn't make a difference in terms of the prejudice or the calculus here. The fact is, the defendant would have known that he was arrested and that he had committed this crime, and that at some point they might charge him with it. So it shouldn't have come in any great surprise when an indictment actually comes down. And there was still about 2 weeks from the time of that indictment to the time of the motion for continuance. So even if his defense counsel received notice later, he didn't. So for all these reasons, there simply wasn't prejudice and there simply wasn't an abuse of discretion. I'd like to speak briefly about the chain of custody, the third issue, and to say that there's no fundamental error because a reasonable jury could have found that the evidence was authentic. The court's gatekeeping function is very low in these kind of cases under Rule 901. The question is whether there's sufficient evidence to support a finding. And certainly there was in this case. There is an exhibit, exhibit number 84, which is also exhibit number 82 in black and white, which is a photo. And I have extra copies if the court would like to take a close look at it. But if you look at this photo, there is a pre-printed label on it, Hotel 630, which we know is the patient identifier number for this defendant. We know that because of trial testimony. We also know that because another exhibit, 81, is the police request form, which says the same thing, Hotel 630 belongs to Michael Abbott. So because of that, we know that the nurse, as soon as he drew the blood, put the patient identifier on these vials and handed them to the police officer. And then we also have plenty of testimony from the nurse explaining his normal practices and how he's never given the wrong blood in 17 years. Essentially, the only evidence going the other way is the nurse's testimony that he usually draws 2 vials, but he never said he always draws 2 vials or he only draws 2 vials. And the police officer saying that she thought she received 2 vials, but then again, she identified this picture as true and correct, showing 3 vials. And if you look at it, it's clear that they usually do draw 2 vials. There's 2 in the holder, and then there's the free-floating one. But just because they often do something doesn't mean that they never do anything else. And given all the testimony, a reasonable jury could easily conclude that the 3rd vial belonged to the defendant. And finally, just a few words on the closing argument. The prosecutor is entitled to appeal to common knowledge, things that anyone in the jury would know. And the statement here was that given the ubiquity of public drunk driving awareness campaigns, the defendant should have known that his actions risked killing people. And that isn't designed to create disgust against drunk drivers. It's simply designed to show recklessness. So the prosecutor was entitled to make such an argument. And if the court doesn't have any further questions, the state would respectfully submit that this court should affirm the convictions and sentences below. Thank you.
Thank you, Mr. Chris. Mr. Coolidge, rebuttal.
Thank you. Going back to the jury instruction on the endangerment charge, the record is fairly clear that the trial counsel did object to the endangerment instruction. He did not like the one that the court wanted to give. And again, as I indicated, they completely left out one half of the sentence. Either you endanger somebody by recklessly endangering them of imminent death or physical injury, and that the words physical injury should have been left in the jury instruction. Going back to the continuance, again, you've indicated that motions that continue usually are granted when there's things such as a lack of preparation for trial. Clearly, we found out in trial that this attorney was not prepared because we found out that he was completely mistaken about whether that hospital draw was done pursuant to a warrant, and then wanted to litigate the issue. And it was denied because it was untimely, which in the middle of trial, a motion to suppress is untimely. But had the state brought up at the time of the settlement conference 2 weeks before and said, you know, this was not a warrant issue, this blood was not drawn by warrant, only the 2 after, then he could have at that point in time, rather than the day of trial, asked for the motion to continue, again, to litigate that issue.
But I guess the motion to continue was not based on lack of preparation. I mean, what was before the court at that time was the statement by defendant's counsel that he was ready to proceed to trial. It was not that he was unprepared or he was mistaken about the fact. It was that he was ready to go. The only reason for the continuance was to try to get a plea agreement. And I'd like you to address Mr. Chris' argument that all this is speculative. It's speculative whether the state would have offered a plea agreement that would have been favorable. It's speculative whether the defendant would have accepted it. It's speculative whether the trial court would have given him 3.5 years and then probation at the end of that for the marijuana. All this is speculative, and I'd like you to address that. Why isn't he correct on that argument?
I can address all of those issues. I know I'm going to go beyond my 30 seconds if that's okay. Okay. Basically, first of all, it's not speculative about the state because she indicated to the trial court, I do not oppose this motion to continue. I am willing to open up negotiations again and give a global plea that will resolve this case. The trial counsel also indicated, now that I have this case here, that this new charges, I would be telling him this is why you should take the plea that was offered to you or whatever plea they're going to offer you. And again, we don't know what that plea was because they were not allowed to go back to have plea negotiations. And
Is it that they weren't allowed or they just didn't? I mean, the court didn't order them that they couldn't.
I understand. They could have taken the time at that point in time to try to negotiate during that week off. But again, as you indicated, the jury had been picked. I don't know whether it was sworn as well. I did not notice that from the record. And so, at that point, you're in trial. So, and so for the reasons stated and in our brief, judges, I would ask that the conviction be reversed.
Thank you. Thank you both, counsel. We appreciate your briefs. We appreciate your oral argument and presentation today. We will take the matter under advisement. We'll issue a written ruling in due course. We'll now take a short recess so we can set up the court for a next oral argument.